Each side gets 15 minutes. You needn't use all of your time, and we don't allow rebuttal. With that, I'll call our next case, and that's 2019 P 1731 Commonwealth versus Rose. Ms. Shee.
Thank you, Your Honor, and good morning. May it please the court, Meredith Shee for Mr. Thomas Rose. Trial counsel in this case provided ineffective assistance on two glaring fronts: the failure to litigate a viable motion to suppress and the failure to retain an expert at trial to provide evidence to the jury in support of his theory that the victim was not credible in her allegation against Mr. Rose. Moreover, the trial judge in this case erred in denying Mr. Rose's new trial motion, where he failed to conduct a hearing and instead relied on a combination of either facts not in the record or gaps in the record which should have been filled by a hearing. I'm going to start by addressing, yes.
I had just one quick question before you begin your argument to make sure that I understand the parameters of your what you're raising. So this is a consolidated appeal from both Mr. Rose's direct his judgment of conviction and his denial of his motion for new trial. But your arguments really only pertain to his motion for new trial. Am I right?
Yes, because the arguments in the direct appeal, they are essentially one and the same. There are no extraneous arguments outside of the new trial motion.
Right. So in other words, our main objective today is to determine whether or not the trial judge abused his discretion in denying the motion.
Yes, Your Honor.
Okay, thanks.
So to begin, I would address the underlying merits of the new trial motion, and I think it might be easier to field any questions that come up as to specifically how the trial judge abused his discretion on any particular point, since the entire body of the claims on appeal are that new trial motion and its denial. The first area of ineffective assistance that was raised in a new trial motion, and the first part that was denied by the trial judge in this case, reviewing that motion, is about the motion to suppress that trial counsel failed to file in this case. And the only motion to suppress that I'm talking about is a motion to suppress the search warrant executed at Mr. Rose's house. There were two other search warrants. Those are not in this motion, in this direct appeal. Now, the main issue with the motion to suppress is the nexus, and that is the issue that Mr. Rose raised. The problem in this case is that Mr. Rose's house was searched on the basis of what I call the generalized boilerplate affidavit from a detective in this case. The cell phone in this case, which was seized by police at the same time they executed the search warrant, really has no value, but was used as the cornerstone, the keystone, I would say, to search Mr. Rose's home. And there really is nothing in the search warrant affidavit to support bridging that gap between the phone and getting into Mr. Rose's house.
Now, because you're saying because the phone was take pictures of the underage victims.
I'm sorry, the question was a bit.
We're asking the same question. Didn't he use the phone to take pictures of the underage victims?
Yes, and that is detailed in the search warrant affidavit. And so I would say there's no question about the search warrant to search the contents of the phone. But on that information alone, the detective then made some generalizations about cases, other defendants in general, and used that to say, well, there must be evidence in the house, so we should go search the house. And
was it more likely he kept it in his car or the van, whatever it was, as opposed to his house?
Well, honestly, in this case, there really didn't have to be any guessing game because the detective had already arrested Mr. Rose and had seized his phone. So there was no question where was the phone likely to be. It was in police custody already. So,
well, I mean, are you familiar with the drug nexus cases?
I'm sorry?
Are you familiar with the drug nexus cases where the defendant makes deliveries of drugs and returns to his home afterwards and leaves from his home? I mean, there the inference is that it's more likely he kept the drugs at his house than he did in his car. So arresting him doesn't leave the police necessarily without probable cause to search his house. How is this?
I agree, Your Honor. And actually, I raised a number of drug cases as analogy in the motion for new trial, and the trial judge who ruled on the motion suggested the opposite conclusion, that these cases are separate because drugs are not typically found in the home, which I would argue, number one, was a legal error because those cases, and I cited several of them in my brief, but in the motion for new trial, also in the brief, those cases don't actually stand for the principle that drugs are not typically found in the home. And I think, to answer Your Honor's question.
No, if I just interrupt, I believe the
Motion,
judge was, just for a second, I believe the judge was only talking about one particular case with respect to that, which is Commonwealth versus Pena. Am I correct?
He said Pena and other cases cited by counsel. He did cite Pena specifically, but in all of those cases, simply seeing somebody dealing with drug transactions and then returning to their home is actually not enough to get into the home. And that is—
Well, that was the state of the law when Pena was decided, but the SJC cleared all that up later in Escalera. I noticed that you didn't cite Escalera. You just cited the old ones.
I did not cite Escalera, Your Honor, but I would say that even in this case, we don't actually have any evidence of Mr. Rose returning to his home in some way that's connected with the criminal activity in this case. And the difference with those drug cases is that those individuals are being monitored with an activity that happens between the house and some other location.
Well, let me ask you this. I didn't understand the judge really being that focused on following that line of cases, other than to say is that what they were looking for here, which is child pornography and photographs of underage individuals, that is an item that is so different than narcotics. That's an item that will most likely be at home. Something like, for example, when the search warrant is looking for tax records or other kinds of records and documents. Those are items that are more likely kept at someone's home rather than elsewhere. Whereas with narcotics, it could be very different. I mean, narcotics will have a stash house, etc. People don't usually have a stash house for like income tax returns, or most likely child pornography. That's most likely going to be found, as was described in the affidavit, on someone's home computer, in their desk, or wherever, someplace in the home.
Well, and I think I have two answers to that question, Your Honor, and that's a good point. I think, number one, the cases that I've cited that do deal, and really all of the cases that I could find that deal specifically with search warrants for child pornography, all have some basis pointing to that specific defendant having some ability to access, store, possess child pornography in their home. Most often they deal with IP addresses. There's one case that the Commonwealth cites in their brief, Commonwealth versus Anthony, that they rely on to say, this is not distinguishable. You can basically suggest child porn is different. It's always in the home. And I would say that if Your Honors look closely at Anthony, it's actually very different from this case. There are a lot of particularized details in Commonwealth versus Anthony that gives some basis to say, yes, you may find this here in the home. There were specific admissions in that case that the defendant owned up to 5 computers, had them in his possession, used them to view child porn, and made, not incriminating, but I would say conflicting and sort of furtive statements to police trying to cover up his ownership of those items. Now, in that case, the defendant was homeless. However, he had possession over a storage locker, which was sort of the analogy to his home. And it was found sufficient that in that case, it was most likely that he was storing those items at his storage unit, was really the only private space that he had. In this case, we have literally no information tying anything to Mr. Rose's home. And the fact that the allegations are tied to his cell phone, which is another digital device, and actually the affiant describes that the cell phone is pretty much capable of being its own computer and storing these files.
But can't we take into consideration, the expert testimony or the expert opinion of the other investigating officers that this type of information would be transferred or could easily be transferred and is usually transferred, however they worded it? There was something more than he took pictures and we want to go in his home. There was expert testimony provided by other investigators.
Well, right. And that is the crux of what is problematic in this case, because that expert testimony is not unique to Mr. Rose. And this is why I raised in both the motion for new trial and in the brief, the analogy to Commonwealth versus White, because in that case as well, there was generalized information offered by the affiant as a detective, as someone who worked in the homicide unit for a long time, had experience investigating murders, and who said that, well, I don't know specifically about this, but I know that people who are involved in shootings and involved in crimes often use their cell phones to communicate.
But the White goes to the search of the phone.
Correct.
not to the search for the, this is a search for, not the phone. Like you said, he was arrested with the phone, so they had the phone, but search for what would normally, in the expert's opinion, be done with evidence from the phone.
And again, I think that is the same situation as in White. And in fact, there's a quote I'd like to read from White. And this is the SJC sort of rejecting the argument that, quote, there could exist a nexus whenever there is probable cause that the suspect was involved in an offense, like we have here, accompanied by an officer's averment that given the type of crime under investigation, the device would likely contain evidence. And if you switch that word device with house, that is precisely this case. And so the affiant is trying to make the leap between an item that actually is alleged to be involved in the case, the phone. They have possession of it. They have reason to believe there was a crime committed and that the phone was involved, and taking that all the way to the bank to get into somebody's house on a mere averment that, yeah, this happens in crimes like this. And that is what I'm arguing.
He's an expert in crimes like this, and it's a question of whether the magistrate was entitled to credit his expert opinion.
But I would argue that in White, there was no discrediting of anything that that officer averred to. I think the SJC in making its ruling didn't say that officer's opinion is wrong. They said you need more particularized information. That is what the Constitution requires. And the risks that are discussed in White similarly apply here, because if the boilerplate affidavit is enough to get into somebody's home, then literally anyone suspected of child pornography, their house can be searched at any time, whether or not there's any information to believe that there are likely evidence to be found in that house, because it's that type of crime.
Do you want to address the prejudice prong? Because in this case, the judge went on to say not only did he rule that there had been little or no chance of success if a motion to suppress had been filed, but he also went on to say even if this evidence had been suppressed, that he was skeptical that it would have made much of a difference. Do you want to address that?
I will, Your Honor. And that is one of the other legal errors, one of several that I think the judge made in assessing the new trial motion, because while there's no Massachusetts case on point, there is a Supreme Court case I cited, Kimmelman versus Morrison, 477 U.S. 365 from 1986. The prejudice prong only goes to the viability of the motion. And here the trial judge did a calculation on how would this play into all of the counts at trial. He went up farther than is actually required in this case. So the real question on prejudice comes down to, was the motion viable or not? And of course, that is why I started with the underlying merits of the motion itself. That's really the only question about prejudice here. So it doesn't go to, well, maybe there were more serious cases charges at trial, and this was on a less serious charge. That's not part of the prejudice calculation here. And so the only other thing I wanted to mention before moving on to the expert issue is that the risks in White, as I mentioned, and I'm sorry if I'm repetitive because I think maybe I did cover this, the risks are really what's at stake here and why I think White applies. This is technology we're dealing with. And in this case, we have the phone. We know what is targeted here. It cannot be a gate key based on completely generalized information not tied to this defendant to get into their house. I think this case would be very different if you even had information that Mr. Rose owned a computer, because then you would at least have arrested Mr. Rose. You know he has access to a computer. You know he possesses one. It's not on his person when he's arrested. I think that would have been a very different case and motion to suppress. But here we don't even have that. We don't have any.
Let me ask you about the failure to call an expert before you run out of time.
Sure.
So as I understand it, you have this expert, and he or she's going to talk about the effects of consumption of a large amount of CCC and smoking marijuana and how it affect a victim or a witness's ability to perceive, right?
Correct.
Do I understand that correctly?
Yes.
And if had he done that, had he called that expert, then he would have been able to conduct a more powerful impeachment of the victim. Is that right?
Yes, but I mean impeachment not in the narrow sense of cross-examination, but actually offering evidence before the jury that then when he went to go do his closing argument, he actually had evidence to talk about to support his theory. In this case, he only got one.
To impeach her ability. So my question then is, do you have a case from the appeals court or the SJC that we agree that someone was ineffective for not doing a better job impeaching a witness?
Yes, and I think the case I cited, although it's unpublished, is it's pronounced Zubrit. It starts with a CZ name, but I think that most
Do you have any published ones?
I don't
Do
have,
you have any published ones?
but I do think that the cases I cited in EPS and also I'm losing the site here about ineffectiveness related to an expert witness to get the evidence needed to be able to marshal your theory at closing. And so impeachment here is a broader term than simply directly attacking the witness on the stand. That's not what I'm talking about, and that's not what I argued.
Okay, we understand. We're going to have to leave it there.
Thank you.
Mr. Doherty.
Unmuted. Good morning, and may it please the court. Andrew Doherty for the Commonwealth. I'm asking that the court affirm the trial judge's denial of the defendant's motion for a new trial because the trial counsel was not ineffective for failing to file what would have been a fruitless motion to suppress, and was not ineffective for failing to call a witness, as such a witness would have not just undermined but damaged the defendant's trial strategy. Turning to the motion to suppress, I think it's important in thinking about this case to look at the particularized information that led to the ultimate conclusion that there would be child pornography found in the defendant's home. And in the affidavit, what we learn is that the defendant was a serial sex offender with that was a level 3 sex offender with numerous sex offenses on his case. That's in paragraphs 3 and in paragraph 6P of the affidavit. We then learn that he has a demonstrated and continual sexual interest in children. We find that in 6F, where he requests that a 15-year-old give him a video of her naked, or at least with exposed breasts. We find in 6G that he actually did take a digital image of a photograph of a child's exposed breasts, requested oral sex from a 15-year-old in 6J, and described a 12-year-old as having a great body in paragraph 6L. So at that point, and the fact that the defendant had multiple cell phones, at that point, we know that the defendant had a sexual interest in images of children. And we then go to Detective Bruce Edwards's, or Sergeant Bruce Edwards's, what he offers with respect to how people with a sexual interest in children, how they commonly use, access, and secrete these digital images, which he describes as prized possessions. Yes, there is no direct evidence establishing that the digital images would be kept in his home, but in an affidavit, there isn't a requirement that there be direct evidence. Reasonable inferences can be relied upon to establish that nexus. So in this case, and I do refer to Anthony in that case, and also I didn't cite it in my brief, but Commonwealth v. Kenny, it's at 449 Mass 840, is a similar case where a person's training and experience in this direct crime, which is production of child pornography, does establish that nexus into a person's home. And in some respects, it is common sense that a person who it's clear that he has produced a digital image of child pornography is going to keep that in a place where he can enjoy or use or keep hidden from the world this prized possession. And that's really what distinguishes this case from drug cases. It's what distinguishes this case from potential, this guess, I suppose, that's in white, that since everybody has a cell phone and it's common for people to talk about stuff on their cell phone, it's going to be in their cell phone. We're not just relying on common sense, we're relying on the expert testimony regarding, or expert portion of the affidavit that establishes that link. And that is something that has been held since Anthony and Kenny, to say that that's appropriate. And so, given that the question is there a reasonable likelihood that this digital images and potentially others are going to be in the defendant's digital devices, that established the probable cause nexus needed to search his home. Turning to the second issue with respect to trial counsel's failure to call an expert, there was no error in the trial judge's denial of his, and it's important to recognize that Judge Kaplan, who's now retired, was the trial judge who saw the evidence come in and was able to sort of see for himself how this evidence could have played out. But I think it's important to note first that it was clearly a strategic decision that was made by an experienced trial attorney. Andrew Stockwell-Alpert is well known in the Suffolk Superior Court and for having tried many, many cases and tried them well. In this case, his trial strategy was aggressive in the sense that he put right before the jury, right in his opening, he's saying, this is a repulsive case, and this individual, I think he describes him as a creepy drug dealer. His trial strategy is to say, who else are they going to blame? Who is this victim going to blame when she finally gets caught having run away from home, having used drugs, having suffered an overdose? Who else is she going to blame but the creepy drug dealer in doing this? That's and he never wavers from that argument. It's present. Every time that there's an inconsistency in the story, he uses that to highlight, not to attack their credibility as their ability to perceive and recall, but to show that they are making this up. And nowhere is that better demonstrated than in Attorney Stockwell-Alpert's closing argument, when on page 69 on day 4 in the transcript, what you see is he starts talking about the incident in the van, which is where this drug expert's testimony would come in. And he says, he talks about the inconsistencies, how it was different from the first trial and different from the second trial, and sort of speculates, why are there these inconsistencies? He says, was it this? Was it the drugs? I submit to you, it was made up. That, to my reading, that is an utter rejection of the idea that this was that the jury should consider the idea that maybe she just got it wrong. And the reason he did that, and I think it's clear on the record, the reason he did that is because to concede that maybe she got it wrong and maybe it was the drugs that are making this hard, or maybe she's hallucinating portions of it or whatever, it puts a 15-year-old child who's intoxicated into the creepy drug dealer's van in the middle of the night alone. That picture before the jury, to suggest that through the use of this argument that it was her testimony was the product of intoxication through the triple C's, it creates a tremendous amount of harm to his overall strategy, which was this was an entire concoction. And so the trial court was reasonable to do this without a hearing, because there really wasn't much more to say in that regard. It was clear on the record and clear in the judge's eyes, having seen the trial, that this would have undermined the trial strategy. So there was no abuse of discretion here. Unless there's further questions, I think I've said everything I need to say, and I would otherwise just rest on my brief.
Seeing none, thank you, and thank you both.
Thank you, Your Honor.
Take it under advisement.
We're live.
Welcome to the appeals court. I am Justice Meade. With me this morning are Justices Vuono and Lemire. Will be your panel for this case. If we run into any technical difficulties, fear not, we will do our best to reestablish contact with you, and no one will lose any of their allotted time, which is 15 minutes aside. You needn't use all of your time, and we don't entertain rebuttal. With that, we'll call the next case 2019 P222, Commonwealth versus Brockington. Mr. DeMeo.
Good morning, Your Honors. May it please the court, Christopher DeMeo for Sharon Brockington. The two appellate issues I want to talk about this morning are the vehicle stop and then the pat frisk of Ms. Brockington. Obviously, in between these, there was an exit order, but that's not an appellate issue we've raised. So turning to the stop occurred after Ms. Brockington had made a visit at 33 Vassar in Dorchester. This is apparently a two-family house that had been the subject of some complaints the prior year. A neighbor who happened to be a police officer, Xavier, had complained about foot traffic. He thought it was consistent with drugs. BPD narcotics got involved. They did some surveillance. There were a couple of arrests, one in mid to late May 2015, and then one in early 2016. And then we have about 7 months that passed where the BPD narcotics unit did not observe any suspicious activity, despite a couple stakeouts a week, according to Officer Leone. Now, the neighbor, Xavier, did continue to complain, but absolutely nothing is the word Leone, the phrase he used when describing what they'd seen. So that's how things stood on January 2nd, 2016. A bit after midnight, Ms. Brockington pulls up. Her driver, Deshaun Underwood, meets up with another car. They go inside. They're inside briefly. I think everyone describes it as a few minutes or under 5 minutes. They come out, they go their respective ways in their respective cars. So the question is that reasonable suspicion, if you put all that together, that the police have just observed a drug crime that would justify a stop? And we would submit that it is not. Is it consistent? Sure, it's consistent with a drug deal, but it's consistent with a lot of other things too. And that's really the question for the court is under the Barretto case, which both sides cite, which the SJC decided about a year ago. And going back to the Reed v. Georgia U.S. Supreme Court case, it's for the court to say, an officer can certainly say, in my experience, I've seen this before, and when I saw this, it ended in an arrest. But the question for the court is there enough innocent activity that would be swept up in that it's a burden on the Fourth Amendment? And we'd submit this case. We have, Mr. DeMeo, we have plenty of cases, as does the SJC, that says the police don't have to exclude innocent explanations for the behavior to form reasonable suspicion. Here, it's not just any house. It's the same house they've been watching. It's the same house they've seen in the past with the same activity, and would have resulted in arrests for drugs. I'm not aware of any case that has a 7-month time lag that says that's still fresh enough that they can take it under consideration. I don't think the Commonwealth has cited any. So I don't know how far that will get you. And I disagree. Is there a staleness facet of reasonable suspicion like there is in search warrant cases? Well, it says in, I think Joan Spinell says, just because you have an arrest, it's not in perpetuity reasonable suspicion on that block. That at some point it goes away. And we have testimony, the officers themselves testified on cross-examination. If you run a drug house, if you run a crack house and you become known to the police, you don't tend to stick around, do you? And the detective Gaines agreed with that. And we had a couple arrests here. So I would submit it's not at all clear on January 2nd that this was an ongoing drug operation. And I disagree that about excluding innocent explanations. That's the whole point of Reed v. Georgia. That's the whole point of Barretto. And that's what happened in Barretto. The police said, well, Barretto was really a stronger case for the Commonwealth. They came out of the building, did something in a car, reached in, walked away, the car drove off, he went back inside. I would submit that's more suspicious. And the SJC said, well, that includes a lot of other things. Maybe he was asking him for directions or some such thing. So that I disagree, Justice Meade. Had the same, in Barretto, was it the same car had been seen in the past on several occasions doing exactly the same thing? Well, in our case, we don't have the same car. All I recall from Barretto is there was talking about our case. I'm asking about Barretto. Barretto, as I recall, there was a tip that they couldn't use because it wasn't. The police had not observed Mr. Barretto's car on several occasions doing the same thing over and over again, right? I don't think they had. I think it was all about the tip. Right. But what Barretto says that's important is observation of something changing hands is not crucial. It's not necessary to reasonable suspicion, but it's important. And both sides cite that. The Commonwealth cites the part about it's not necessary, but you have to continue on. But it's important. So we would submit, if you don't actually have an observation of drugs or something changing hands, you need something else important in lieu of that, something else probative in lieu of that. Now, what would that be here? I don't know. Maybe a tip, maybe a good tip, maybe if they'd done a controlled buy there. Maybe if somebody had recognized Miss Brockington, this case would be more.
What about Officer Xavier's continued complaints about the same activity?
Officer Xavier's complaints about the same activity had not, and so clearly he's saying there's some foot traffic there, but clearly also there couldn't have been that much because the police said they're there at least twice a week at different times of the day doing a stakeout, and they saw absolutely nothing. So I don't, and that was that was 7 months old, the last arrest. So I don't know how far that gets you. That's certainly not important and comparable, I would submit, to seeing actual stuff change hands. A tip, perhaps, recognizing Miss Brockington or her driver, Deshaun Underwood, but the police didn't recognize either of them or the third guy. And the police knew someone who was involved. If you read the record, there's, it's kind of confusing, but there's a guy named Mohammed Toure. I don't know exactly what if he was buying drugs or selling them, but he had been involved and he was known to Officer Xavier, and he was not the third guy. I don't know where he was by this point. So you just didn't have anything important and comparable. This case, I would submit, is weaker than Barretto. It's ultimately the Commonwealth's burden. I know it's our appeal or the appellant, but it's a warrantless search. It's their burden, and I would submit this case doesn't survive Barretto. Those are the points I wanted to make on the vehicle stop. So I would talk about the frisk with the court's permission.
Mhm.
All right, so to perform a pat frisk, you need an articulable suspicion that the person is armed and dangerous. That's the Torres-Pagan case. Judge Gordon obviously didn't have the benefit of that case, but it didn't really make new law. That had always been the law, but it sort of clarified and cleaned up that area of the law. So Judge Gordon applied the old standard, the wrong standard, which is reasonable fear for the officer's safety. And it may seem that it's parsing it kind of fine to separate, on the one hand, reasonable fear from armed and dangerous, but I'd suggest the issue is the reasonable fear for safety standard gets used a lot in old exit order cases, and there's a lot of case law saying it doesn't take much to justify an exit order. So that might lead one to think, well, if it doesn't take much to justify an exit order and it's the same standard, well, it doesn't take much to justify a pat frisk. But that's just not true. That's never been.
Let me ask you this, because the motion also included probable cause to search, but Judge Gordon focused on the pat frisk and ruled on that leg of the motion.
Right.
Would it make sense to remand for further hearing on in light of Torres-Pagan, to have the judge who heard the evidence address the issue on probable cause?
I think in this particular, I mean, that's certainly an option. It's a peculiar case because the important witnesses were the police officers who testified the first. I mean, they were all important, but I think the key witnesses were.
How the hearing evolved is of some interest as well, but
Yes.
apparently the parties stipulated that the judge could use the transcript, so
Yes,
that's not an issue.
I didn't make an issue of that for that reason, Your Honor. It is peculiar, but because of the posture where you have a paper record, I think it would not be inappropriate for this court to decide it itself. But if the court thinks the better practice is to remand it, I see that as well. But ultimately, I mean, the issue here is so the issue is she armed and dangerous? I would submit just on this record, and this is why I think you can decide the case without a remand. There simply is nothing on the records that would suggest, that would give rise to an articulable suspicion she was armed and dangerous after she got out of the car. She's a 50-year-old woman surrounded by, we're told, 6 or 8 or 10 officers, depending on who's testifying, armed officers apparently. She stands cooperatively for 8 or 10 minutes. The officers say she's not handcuffed. That's not what she said, but in any event, she's not handcuffed. She's doing what they say. Clearly, they don't observe any bulges. They didn't see any signs of weapons. They shined the light in her car. By the time the female officers arrive to frisk her, 8 or 10 minutes have passed. And by the time they escalate the search from outside of her coat to the pulling on her bra, obviously it's becoming more intrusive. I would submit you need more and more justification as you go up that step, and you didn't have anything at that point. And it has to be armed and dangerous. So there's Judge Gordon makes a finding, which is clearly erroneous, that Detective Gaines was concerned that she had a folding knife. He didn't say that, but supposing arguendo, she had a folding knife hidden away in her bra. To be armed and dangerous, she would have to be able to get it out and open it and stab one of these 6 or 7 or 8, 9 officers with guns. So I think that you just have to suspend disbelief on this record to believe that this was a legitimate articulable suspicion that she was posing a danger. They'd already frisked, by the way, Mr. Underwood, and they knew he had no weapons. And that's really the issue here. They seem to be frisking everyone who went to this house. We don't really know what happened back in mid-2015. We know they got the drugs. So unless the people, when pulled over, confessed, I have drugs, there was some kind of search and seizure there. They ordered Mr. Underwood, the driver, from the car. There was no testimony he was suggesting he was armed and dangerous. They said that he didn't have a license and he was feeling around in a way that officers found phony for his license, but they didn't suggest there was a threat to their safety. They frisked him. Everyone was getting frisked, I submit, Ms. Underwood was. And this goes to Justice Lemire was pointing out, they have this alternative argument, there was probable cause. Certainly they wanted to find drugs, and if they found them, they would arrest. And if they didn't, it would be just like Mr. Underwood. They would send him on his way. And that's an illegitimate use of a pat frisk. Pat frisks are to enable an officer to dispel suspicion of danger so he can continue his field interrogation. That goes back to the Terry case. That's not what happened here. Detective Gaines had already questioned Ms. Brockington. He didn't like what she said, he didn't believe her, but he was done. And then he testified when he got out of the car, was there any more conversation? And he said minimal. It was minimal because he was done. He was done interrogating her. By the time the female officers showed up, they weren't doing this so that he could safely carry on his questioning of her as Terry allows. He was done. So we would submit on this record, again, it's the Commonwealth's burden. It's a high standard here because it was given the degree of intrusion, I would suggest, not just a pat frisk of the person, but of pulling on her undergarments. They did not meet that, I would submit. So on the stop case here really doesn't survive Barreto. I would suggest the frisk case doesn't survive Torres-Pagan. And we would ask that the court reverse Judge Gordon and suppress the fruits. In the alternative, as Justice Lemire mentioned, there could be a remand. Those are the main points.
Do you want to address probable cause?
Yeah, I mean, for the same reason, I think there's no reasonable suspicion. I don't see how there could be probable cause here without any observation of anything. Really, all you have from probable cause, you get that she was nervous, which of course she was nervous. She's pulled over by a whole bunch of policemen with marked and unmarked cars in the middle of the night. And you have you have that this was a high crime area, I guess, but I would submit the evidence that it was a high crime area. That also doesn't survive Torres-Pagan because he just said, I made arrests in this area. Under Torres-Pagan, it has to be limited by geography and by time. I'm sure most police have made arrests somewhere in Dorchester at some time or another, but the entire neighborhood of Dorchester is not therefore a high crime neighborhood. And what I mean, this case kind of this sort of checks all the boxes of things the SJC has been concerned with lately. It's a sort of subjective. I thought she was more nervous than people are normally nervous when they're pulled over by 10 policemen. It has the rental car, I guess, but again, as we point out in a footnote, a lot of people rent cars, and that's sort of correlated with income and race. It's very soft. So this is not probative. Again, you need something important. You need important probative evidence to make up for the lack.
Didn't the officer testify in his experience that rental cars are used by drug dealers?
Yes, he did.
There's certainly plenty of cases that say so.
I'm sorry?
There are certainly plenty of cases that say so.
They are. And my point is, this kind of goes back to what you said earlier, Justice Meade, about do they have to exclude everything innocent? Well, perhaps they don't, but you have to take into account that there's a lot of innocent explanations. One of the innocent explanations is people drive zip cars. They're not all drug dealers, and they drive them more, apparently, I would submit.
They're not all drug dealers, but this zip car happens to be parked outside a house where drug dealing has gone on in the past. And then when stopped very late in the night, there's some suspicious behavior by this defendant, not following directions, excessively nervous, avoiding eye contact, moving her hands when she's told not to. Those are not innocent circumstances.
I would submit that's not enough. Again, these are all soft kind of, who's to say who's nervous after when there's 10 police? Who's to say? If they had made direct eye contact, I'm sure we would have heard, oh, I was very suspicious. She was staring me in the eyes. I was very suspicious. She wouldn't put her hands down. So these are not the kind of things I would submit that make up for the probative evidence that was missing here. They're not important enough to meet the Commonwealth's burden. Thank you.
Thank you. Mr. O'Sullivan.
Thank you, Your Honor. May it please the court. I'd like to start with the court's permission with the issue of reasonable suspicion for the stop. When viewing the facts as a whole, as is required in a reasonable suspicion analysis, the stop in the incident case was justified. In laying out the important facts, I think it's important to look at them chronologically. We started with Officer Xavier's initial observations over a period of time of the heavy foot traffic and persons going to that address, which he believed was consistent with drug sales. Officer Xavier, although not a narcotics officer, I don't know that he would qualify under the Kennedy Santeliz cases as an experienced drug investigator. He was a police officer. He testified he'd made 20 to 30 narcotics arrests in his career. So I would suggest he had some experience, that there was some meaning behind these observations. There was also his encounter with Mr. Toure, in which Mr. Toure complained about a drug dealer being in his building, and there was some conversation about selling drugs in the building or failure to sell a certain person's drugs in the building. We had the two incidents in May and June where Officer Leon, an experienced narcotics officer, observed similar activity to what he eventually observed this defendant engaging in, which were motor vehicles.
What do you make of that 7-month span of time in between the fact that Officer Leon makes an arrest and the incident that we're concerned with here?
Sure.
That's a long period of time.
It is a somewhat long period of
7 weeks or something like that.
It is a somewhat long period of time. I don't necessarily know that 7 months makes the information stale, considering that there are at least
Do you
two
think that
repeated.
an officer could obtain a search warrant of a residence, for example, if there had been a drug sales, let's just say drug sales that were clearly substantiated in May, and then the following January they execute a search warrant? Would that be probable cause? Would they be able to rely on that information?
Well, I think you can't divorce it from the observations in January as well here, because the observations in January matching that pattern.
You mean by Officer Xavier, not by the narcotics officers?
Well, both. I think by the narcotics officers in January, observations of the defendant, that her conduct and Mr. Underwood's conduct matched the pattern they had previously seen. So that was some current information, I think, that they had to consider. And then also Officer Xavier's observations, I also think, colors the analysis. Although Leon stated he would observe the residents a couple times a week, there was also clarification there. Xavier was saying that he was notifying Leon of the activity every time he was seeing it, and Leon had testified that when he was being notified, he was either busy, he was working in another area of the city. So it appeared from the record, my reading is that Leon was never able to essentially go to the location at the time Xavier was making his observations. But given Xavier's experience, given Leon's testimony, is what that meant to him.
You would say that there really was not a span of time in which there was nothing observed. It was just the observations were of a different nature.
Or they weren't observed by Leon, I guess. They weren't observed by the experienced narcotics officer, but given his testimony as to what that conduct meant, and given to him, and given his testimony that he had confirmed that conduct resulted in drugs on at least 2 prior occasions, given Xavier's experience, although maybe not as deep as Leon in narcotics, but he did have some narcotics experience, I think all of those give meaning to whether this information was timely or stale. And I would suggest that given the totality of the information, a continuous course of conduct was established at this building. I would note, I think the case that the defendant primarily relies upon to make their staleness argument is the Reddington case. And the one point I would make about that is, in addition to being a probable cause analysis in Reddington, that case also involved unverifiable tips of informants. And so, in that case, the Commonwealth was trying to show the currentness by these confidential informants.
Right. That's a different scenario.
And here we have a named individual who's not only a named individual, but he's a police officer. He's a police officer with experience in narcotics arrests, making these observations to bolster that this is a continuous
So
operation.
if we get to reasonable suspicion to stop the car and the exit order is not challenged, we have two roads we can travel from that point. It's either a probable cause search or reasonable suspicion that she's armed and dangerous. Do you agree?
Correct.
And the Commonwealth suggests it's armed and dangerous, but in light of Torres Pagan, that may be a tougher road to hoe. What about probable cause? Do we make that determination or do we remand?
Just answering that question very pointedly, because I would say that this court can affirm on any basis. So I do believe this court has the ability to decide the case on a probable cause to search basis if it wishes. I don't know that remand is necessary. I guess I don't know of any reason why the court couldn't remand for the trial judge to make the decision, but I would suggest that.
Well, would there be findings of fact that need to be made at that point?
I don't believe so, because it was an argument we made below. I believe that the trial judge chose not to reach it because he didn't, or I can't remember if it was he or she, but he or she didn't need to. So, I don't know what additional record evidence we would present on probable cause. I think the stop itself was, we presented all the evidence that we had on the circumstances of this particular stop and search.
You might want to present more on reasonable suspicion under Torres Pagan, though.
And I don't know, Your Honor, that Torres Pagan really, and if this court feels that, the wrong standard was applied, then, we'll happily have the case remanded and we can evaluate that. The motion judge analyzed the pat frisk as requiring what he, citing to the Washington case, an objectively reasonable apprehension of danger to themselves or others. And I think that standard is actually pretty consistent with Torres Pagan. When we talk about an objective reasonable apprehension of fear, I think that's pretty analogous to reasonable suspicion of armed and dangerous, bless you. And the evidence that was presented, I think, establishes under, whichever language you want, this court would want to apply. In addition to what was observed prior to the stop, there was the nature of the area, and I would draw some distinctions for my brother on that. I think that Officer Leone actually testified pretty specifically to the area. He testified specifically to 33 Vassar Street. We had knowledge of the 2 prior incidents where drugs were recovered from that specific address. Officer Leone wasn't just averring that, Dorchester, or all of Dorchester, or all of his district was a high crime area. He outlined specific streets. He mentioned 6 specific streets within that area, so he did delineate it to a specific boundaries, so to speak. He stated it was known specifically for drug arrests, and outlined how many arrests he had made in that area, which was numerous. So I think there was a more specific level of information than what my brother has argued. And then in addition, there were other factors observed at the time of the stop, which, although maybe taken and parsed out individually might seem innocuous, again, this is a totality analysis. The defendant repeatedly took her hands out of Gaines's line of sight and towards her lap. Gaines demonstrated this by showing that she was placing her hands on either side of her right leg. She repeated those movements after being directed to make sure that her hands were visible. She appeared nervous and avoided eye contact the late hour. Both parties apparently had given officers false answers as to where they had been coming from. So all of this conduct, I would suggest, shows a reasonable suspicion that she was armed and dangerous. And the inquiry isn't, does the officer need to be certain that she's armed and dangerous? The inquiry is a reasonable suspicion she's armed and dangerous. I think one case, although it's a post or a pre-Torres Pagan case, as many of them are, the Combo cites in its brief is the Goey case, Goewey. I think the facts are pretty analogous in that one, where the suspect is in a car reaching into the air around him. The officer could not see the suspect's hands. SJC found that a pat frisk was justified in that case.
Mr. Goey, though, ducked down like he was reaching for something at his feet. And we don't have that here.
I don't know that he did. Maybe my reading of Goey was.
I wrote Goey when I was in the appeals court, so I'm certain he did.
Okay. Well, the SJC opinion.
I wouldn't go against that ironclad memory.
No, Mrs. Vuono was also on the panel, by the way.
The SJC opinion, in any event, describes it as reaching into the area around him.
Right.
And so.
But another thing you didn't have in that case, that you have in this case, an odd fact, is the point that you're not odd, excuse me, but different, that your brother points out is the time between the exit order and the actual pat frisk, right? That there's a period of time where we're waiting for female officers to arrive.
Sure, and I would point the court to the Stampley case, which I think is extremely analogous to this one. And what that says is it doesn't need to be immediate danger. And I think Gaines articulated it quite, well, in that he said if, essentially what he said, or I'm paraphrasing, is that his suspicion was aroused that she was armed and dangerous. He took her out of the car, had her watched by multiple officers. At that point, because she was compliant, she was being watched by multiple officers, his preference was to have a female officer frisk her. And just because she was compliant at that time, there was maybe no immediate danger, it didn't alleviate the concern. I think what Stampley says, it acknowledges that even though a person may be compliant when they think they're being watched or when they're under closer scrutiny, it doesn't alleviate the danger that the officers perceived in other instances. And as long as there's a legitimate stop that's ongoing, the police still have a basis to make that check and make that pat frisk. Leon testified that this car was impounded and towed. No rental agreement was ever produced by either Mr. Underwood or the defendant. So there was legitimate police business, going on during the course of the stop. And I think once the reasonable apprehension of danger or the reasonable suspicion of armed dangerousness arose, the lapse in time while she was being watched doesn't really make a difference. And then I would just like to, I see I'm running short on time. I would like to make one more point going back to GOE and some of the furtive movement cases. I think sometimes there's a distinction that's attempted to be made between maybe, reaching to an area of the car. The defendant here was clearly reaching towards her body, her person, towards underneath her legs. I would just state that I don't think it makes it any less dangerous for the officer in that moment. A weapon could certainly be concealed on someone's person.
We understand, Mr. O'Sullivan. We're gonna have to leave it there.
Thank you, Your Honor.
Thank you both. We'll take this under advisement.
We're live.
Good morning. Welcome to the Appeals Court. I'm Justice Meade. With me this morning are Justices Vuono and Lemire. It'll be the panel for this case. Each side is allotted 15 minutes. If we run into any technical difficulties, we'll do our best to reestablish contact, and no one will lose any time. We do not entertain rebuttal. We have read everything. So with that, I'll call the next case, 2020 P46, Donahue versus the Trial Court for the Commonwealth of Massachusetts. Mr. Trombetta.
Thank you, Your Honor. Your Honor, I believe that the case comes down to a simple one. It involves an employee entitled by the Commonwealth. It refused to pay him amounts which he had earned. And the amounts are more than $75, which is, 75 hours, which, entitles him to that. I understand he is owed about $800, maybe a little bit less. And he said just to get his pay. And if you look at the management agreement, you'll see that it goes on to say that the immediate manager cannot award more than 75 hours. So pay in excess of 25 20. I apologize, Your Honor. I have a slight well, anyway, I think we
No worries, we follow you.
All right.
Can you tell us how starting with the Wage Act, why does the Wage Act apply, and why isn't the trial court entitled to immunity?
Well, Your Honor, I don't think that the Commonwealth is entitled to immunity. I think there's Chapter 149, Section 148. There's Mass General Laws 125, Section 1, and I believe there's Mass General Laws 268, 16. I think all those, state pretty clearly that, there's nothing else to do. Now, I have all these other cases that I've cited, and it seems to me that
well, again, let's start with the Wage Act then. All right.
Okay.
When the claim involves someone who's an agency of the Commonwealth or the Commonwealth itself, you have to establish that it involves mechanic, workman, or laborer, or that the conduct occurs in a penal institution.
Correct.
So if you can't establish those, then the Commonwealth's entitled to immunity on that claim. So please explain.
Okay, if you look at if a court officer, okay, is in, say, a courthouse, and this applies to all courthouses, you'll see, at least I understand, that about 75% of that representation will go to the
Handling criminal cases.
correct, Your Honor. And I don't want to yell. If I yell, I'd be much better. But I'm trying to do it in a more relaxed, even though it's not relaxing for me. I think.
So you're suggesting because he handles criminal defendants that he's working in a penal institution?
Well, Your Honor, if you look at the definitions in the statutory citations which I've cited, and those are the three that I just said, and there may be a couple more, I think that they do point to that they were, they had no other place to go, okay? And the reason that is so important is that, if you come in and you do all this work and you're owed 846 hours, and they say, well, we'll pay you someday. And what is the guy supposed to do? He's like, well, wait a minute, I'm supposed to get paid. And they say, well, we just have to pay you. And there's nothing in the agreement, And the bottom line is when you look at the Paris case, it's nearly identical to this case. So when you look at them, I'm sort of like.
Paris involved a jail guard, right?
I believe so.
So that is a penal institution.
That's true. But a penal institution also includes the
places where prisoners are held for court appearances.
Well, you could, yes. And the thing is, when they're brought in, the chain of custody changes. Okay, I'm sorry, I'll have to talk a little louder. But the change in the ownership, okay, of the individual, okay, goes to the individual who is acting as the court officer. Okay, sometimes those individuals are held overnight. Sometimes, well, I think all times, they bring in, okay, people that stay overnight. Now, these people are under the supervision of the court officers, okay? And if you try to take that away, you're sort of saying, well, you're back in this, what are we supposed to do?
Do you have any evidence that suggests that courthouses house prisoners overnight? They don't have food facilities or showers, or, I mean, these are holding cells. I mean, I mean, that's an aside, but if are you trying to suggest that because they come from a penal institution to a court of justice, the court of justice then takes on the persona of being a penal institution?
Well, yes. I mean, because if you look at the
All right, and if we don't accept that, then the immunity applies under the penal institution.
I can't say that right now, Your Honor, but I would say our strongest argument is the fact that, see, the thing that is most, I'm sorry, is most harmful, well, not most harmful, most helpful, is that there are two avenues to go down. There's the first one where we're saying, oh, okay, it's, you know, it's not a penal institution. And then now there's the other one where we're going to say, hey, it is a penal institution, and here's this other I'm so sorry about this. What is it?
Just pause for a second. Mr. Clerk, can you reset the clock for 4.5 minutes? Arcangelo, thank you. Go ahead, Mr. Trombetta.
And then the other one is just that, you know, the second one is, I think it's labor and something else. And, you know, those are the two things that we'd be looking at. I do think that laborer, not the laborer, the other case, I don't understand how it could not be a, I don't understand how it could not be a, how it could not be a, well, anyway, it's.
You mean penal institution?
Excuse me?
Are you trying to say it has to be a penal institution?
No, it could not be a penal institution.
Yeah. Mr. Boudou, I'm sure, is going to tell us that when we look at this issue, that we have to look at the whole function of the entity. And here's the trial court. And seeing as how the whole function of the trial court department is not one of penology, I don't understand how it can be a penal institution.
Well, it is a penal institution, Anna, and if you look at everything else, what's different about it? You know, there's nothing different about it. And if you look at this, if you look at the associated case with the sheriff, you know, there's not a lot of difference there. And what we're saying is, okay, you guys are okay, we're going to give you the gun to go, okay? And you can go get your you know, get your money, okay? But then with these people, you're going to say, well, no, you can't. And then the question is, I'm going to say, well, why not? I mean, why? And the thing is, I think it's because there is no basis to go ahead and shut them down. And the reason is there's no case saying that. Okay, there are cases saying, oh, okay, you know, we got the ruling, blah, blah, blah. And now all of a sudden, out of nowhere, we're going to get this case and it's going to say, oh, it's, you know, just because of because of these guys, we think they're, you know, they're coming from, you know, something else, and they're not, you know, within the, I'm so sorry, I have.
But I think we understand your argument. Is
Right.
there anything else you'd like to tell us?
Well, I've covered the Suffolk County Sheriff's case, but you know, I think it's really important to think of that, because in this case, okay, if you let the these people go, okay, and you say, well, we can't give you any help, you know, then what are those guys gonna do? I mean, you know, because they're counting on getting paid. And when you think about it, if you guys let them, excuse me, if you let them go, then I think it's, I don't want to say it's wrong, but I do. So that's all I have for now.
Okay. Seeing no questions, thank you very much.
Thank you.
Mr. Boodoo.
Thank you, Justice Meade, and may it please the court, Assistant Attorney General Jesse Boodoo for the trial court. And I'll keep with the focus on the plaintiff's wage act claim in particular here.
Can I ask you a factual question before you dive in there? How does the 75 under the CBA, how does the 75-hour cap work exactly?
So under the CBA today, there's a memorandum agreement in effect that went into effect. I believe the last one was December 2018, that provides that on a biannual basis, the trial court pays down the accrued compensatory time down to 75 hours. That 75-hour figure would then remain until the time of retirement or when the term of service ends, at which point the court officer would be paid out or cashed out.
Anything greater than 75 hours in a given year gets paid?
Paid down on a biannual basis. And my understanding is that as of last week, Mr. Donahue was paid down to 75.
Okay. Thank you. I'm sorry to interrupt. Go right ahead.
No, of course, Your Honor. There were, in our view, two fundamental problems with the Wage Act claim here, a sovereign immunity problem and a pleading problem. The sovereign immunity problem turns on the language we've been talking about so far, mechanic, workman, labor, or penal or charitable institution. Mr. Donahue, as a court officer by statute, is a trained member of law enforcement, invested with the same power to arrest on courthouse grounds as a police officer would have. And it is that status as a professionally trained member of law enforcement that most clearly precludes the possibility that he could be a workman, mechanic, or laborer within the meaning of the Wage Act. There are two cases in particular that I think are most helpful and I want to point to here. The first case is Newton. And what Newton tells us is that this language, mechanic, workman, laborer, is generally meant to refer to people who work with their hands or use tools or engage in other kinds of what we might call manual or physical or menial labor. Court officers don't fit into those categories because they are law enforcement professionals. They are not employed to provide manual or unskilled labor. The second case I want to point to is Devney's case, which is one of the older SJC workers' comp cases that's cited in Newton. And what the SJC said in Devney is that firefighters can't be workmen, mechanics, or laborers because those words taken in their ordinary sense exclude a quote unquote trained and disciplined core of officials who are sworn to protect the public. And that's the same rule that should apply here. Court officers are no more manual or menial laborers than the firefighters were in Devney's case. That then brings me to the penal or charitable institution language. And my brother's argument, as I understand it, is something of a two-step argument. He argues first that a courthouse holding cell taken alone is a penal institution. And he argues second that if it is a penal institution, then a courthouse as a whole, or the trial court as a whole, must also be a penal institution. And we, of course, disagree with that argument at both steps. As an initial matter, the holding cell in a courthouse, even taken alone, isn't a penal institution, either in the ordinary modern sense of those words or in the more historical sense that penal or charitable institution was used in the Wage Act. In both senses, penal institution refers to a jail or prison or house of correction, not just any secure space, but the particular secure space where someone would be committed to serve a term. That's also true if we look, as Newton did, to the definition in chapter 125. Under chapter 125, a penal institution is a correctional institution, and a correctional institution is a space or building or facility for the custody and control and rehabilitation of committed offenders and others. And while certainly a holding cell could provide temporary custody or control, it isn't, nor is it intended to provide rehabilitation to committed offenders. With that said, we can also move on to step two of the argument, so to speak, and assume for the sake of argument that a holding cell is a penal institution, because even then we submit the argument doesn't hold together. The decision in Newton tells us that the assessment of whether the agency employer is a penal or charitable institution has to be undertaken at the level of the institution as a whole, or the employer as a whole. And the character of a holding cell does not define the character of a courthouse. A courthouse is, as the Superior Court, I think, correctly held, a center for both criminal and civil justice. It is not a penal institution, and it is not a correctional facility.
Can I just jump back for a second with a question? The Judge Dupuy, I think it was, had talked about the professionalism and of a court officer and having to take a written exam that they have to pass. And Mr. Donahue became a court officer before that was a requirement. What do we make of that?
Well, so I would say two things, Justice Meade. One is that it's true that Mr. Donahue himself became a court officer before the exam went into place. But I don't think, well, first of all, we are talking here about a claim filed in 2018 that is based on overtime accrued in 2014 or after. So I think we are looking at the function as it exists today. In addition, I think what is most material and important about the test is not whether or not Mr. Donahue took it, but what the test in general reflects about the expectations for professionalism and training for court officers in general. And that was true both before and after the test was implemented as a statutory matter. Certainly even before the test was implemented as a statutory matter, it was true also as a statutory matter that court officers were law enforcement officers with the power to arrest.
Thank you.
I'll address just briefly what we saw as the pleading problem here. The complaint was exceedingly threadbare. It did not plausibly allege any violation of the plaintiff's substantive rights to the timely payment of wages. It did no more than recite the elements of the claim in a conclusory way, and that wasn't sufficient. And the pleading problem here was, I think, especially notable in light of the Paris case, which I know we've discussed already today, but Paris tells us that where a CBA governs the timing of particular wages, it's the CBA then that defines the employee's substantive rights. The Wage Act merely defines the remedy. And Mr. Donahue here did not allege any violation of the CBA. The complaint doesn't mention the CBA. The complaint doesn't articulate the alleged theory of wrongful detention at all. So for that additional reason, there was no plausible allegation of any violation of the Wage Act, and the judge, and as to the Wage Act claim, could be affirmed on that alternative basis. As to our other arguments, the trial court is content to rest on the briefs, although I am happy to answer any questions the panel may have.
Seeing none, I thank you both, and we'll take this under advisement.
Thank you, Your Honor.
Justice Lemire will be the panel for this case. If we run into any technical difficulties, we'll do our best to reestablish contact and no one will lose any time off their clock, which is each side gets 15 minutes. And we do not entertain any rebuttal. With that, I'll call the case as 2019 P1676, Commercial Wharf East Condominium Association versus the DEP. Mr. Allen.
Good morning. May it please the court. My name is John Allen. I represent the appellant, Commercial Wharf East Condominium Association. To resolve this appeal, the case must be viewed through the prism of the 1960s and 1970s in Boston. It's very easy to forget now, but Boston was a very different place then. Commerce along the waterfront had vanished. The wharves themselves were deteriorating. Residents had fled. The tax base was diminished. The city needed a change, and urban renewal became one of the vehicles to save it. When viewing Commercial Wharf's evidence through this prism, it becomes impossible to conclude that Commercial Wharf's use today of its property is not authorized. The vital public purpose of the 1960s and 1970s cannot be ignored, like DEP attempts with different goals in mind. And I want to go directly to that time period. In June of 1964, the BRA, the City Council, and the mayor adopt and finalize the Downtown Waterfront Urban Renewal Plan. And the plan's purpose is to revitalize the waterfront and to promote redevelopment with a specific focus on residential communities. Commercial Wharf itself is identified in the plan as parcel B1, and it's identified for redevelopment into specifically a residential community with general business uses, including a mandate of at least one private parking space per unit. And mere weeks after the finalization of the urban renewal plan, the legislature gets together and they pass Chapter 663 of the Acts of 1964. And they do so in order to implement the urban renewal plan. And the act really did essentially two things. First, it established the BRA as the arbiter of uses, giving it a veto over any license issued by DPW at the time. But more importantly, it also transferred the tidelands that are at issue in this case, including Commercial Wharf's tidelands, to the BRA. The legislature decided to transfer all right, title, and interest of the Commonwealth to the BRA. And it is this legislative transfer of the Commonwealth's rights for the public purpose of urban renewal that authorizes Commercial Wharf's uses today. And the Newburyport case really proves this point. That's 9 Mass Appeals Court 206. And in the Newburyport case, this court analyzed Chapter 702 of the Acts of 1967. This was passed nearly 3 years after the act that's at issue in this case. And it's a virtually identical statute. In that statute, the legislature as well transferred all right and title and interest of the Commonwealth to the Newburyport Redevelopment Authority. And this court, citing directly to the seminal case of Boston Waterfront, this court held that it essentially could not be credibly claimed that the transfer of the tidelands under that statute to the authority for inclusion in an urban renewal project was not for a public purpose. Having found a proper public purpose, it then ordered the land court on remand to consider the tideland grant under that statute in the context of the Boston Waterfront case and whether the plan comported with the public purpose of the act. On remand, the land court found that it had. They found that the Newburyport plan comported with the public purpose of the act, that it was for a public purpose, and that the public would be well served by it. This same holding in the Newburyport case, the same findings as in Newburyport, should apply equally here to Commercial Wharf and the act at issue. And what DEP does instead is that they essentially argue that none of this vital, important time period really matters. And they say that because of the subsequent 1979 Boston Waterfront case, and of course the subsequent 1983 amendments to Chapter 91. But Boston Waterfront was really only a game changer for properties that did not already have authorization for its existing uses. So for properties like Commercial Wharf and for properties like the tidelands at issue in the Newburyport case, where the legislature had already decided and already spoken as to legitimate authorized uses for a public purpose, no additional authorization was needed. And Boston Waterfront really held that when there's a grant of the tidelands, the grantee owns it in fee simple, but there's a condition subsequent that must be adhered to. And in this case, the public purpose approved by the legislature and the condition subsequent that Commercial Wharf must adhere to today is as set forth in the Urban Renewal Plan and as set forth in Chapter 663. And DEP was really only able to claim a lack of authorization for Commercial Wharf today by ignoring the legislature's passage of Chapter 663 to accomplish the urban renewal of Boston. And on this key point, in ignoring the legislative act and analyzing Commercial Wharf's legislative authorization, DEP failed to adhere to their own regulations. So 310 CMR 9.051D, it requires that in interpreting a legislative grant of tidelands, like Chapter 663 here, DEP must take its fundamental guidance from the act itself, and they must make a determination of the express or implicit use and purpose so authorized. DEP failed to perform this obligation in this case. They did not submit a single piece of evidence into the record below. DEP was required to perform a full inquiry of the facts at the time to analyze and review the legal precedents, and then to set forth that inquiry into the record through competent evidence in order to demonstrate what its findings actually were as to Chapter 663. This mandate was ignored. And they did so because it would be impossible to conclude that Chapter 663 did not, at the very least, implicitly establish a public purpose of urban renewal for Commercial Wharf's tidelands. This is clear error warranting reversal in this case. What we have here is we have Commercial Wharf's use.
Do you mean reverse, or do you mean a remand?
Well, we believe, Your Honor, that the record actually shows that there is sufficient evidence in the case to demonstrate that Commercial Wharf is actually, in fact, authorized in the first instance. But certainly, at a minimum, we believe that the case should be remanded to take, like I said, at the very least, the findings that were required in the Newburyport case, the findings that were required by the land court, the findings that are required by DEP's regulation at 9.051D. At a minimum, that should occur in this case. But we do say that the uses were established by the special acts, the uses that are still in place today, unchanged, and there were no structural changes at the time. So DEP admits that a license would not have been necessary because there was no structural changes to the wharf itself where the parking at issue sits. So they didn't need anything else beyond the establishment of the uses as set forth in the Urban Renewal Plan and the special acts. So if you view the public purpose, again, through this time period, we say it would be impossible to conclude the Commercial Wharf is not authorized. Now, we don't believe that Commercial Wharf required any further legislation. But importantly, in 1974, the BRA, possessing the Commonwealth's public trust rights in these tidelands, actually did in fact execute with Commercial Wharf's developer at the time, the 1974 Rehabilitation Agreement. And that Rehabilitation Agreement was recorded at the Registry of Deeds, and it sets forth the specific approved uses for Commercial Wharf, including the parking and vehicular access that's at issue in this case. So to the extent anything more was in fact needed, it is seen through the rehab agreement executed with the BRA. The evidence shows that the DPW was aware of this development. They were working hand in hand with the BRA to review the development, and that the recorded rehabilitation acts as the recorded documentary proof of Commercial Wharf's authorization. And so this evidence, lengthy history, it really shows that this is not necessarily your typical 30A agency appeal, right? Typically the facts are fairly narrow, the issues are somewhat limited, but here we have material facts and issues dating back 40, 50 years. Despite this, incredibly, DEP streamlined the proceeding, improperly utilizing summary judgment to enter a decision against Commercial Wharf. And DEP's recommended final decision on summary judgment, which was adopted in full by DEP's deputy commissioner, really suffers from several fatal errors of law. At summary judgment, DEP, of course, was precluded from resolving factual disputes, weighing the evidence, finding that Commercial Wharf had failed to sustain its burden, or that evidence was lacking. DEP was required to view all of the evidence in Commercial Wharf's favor, but these fundamental concepts were simply ignored by the presiding officer below. And there were several key material issues of fact that were wrongly resolved against Commercial Wharf. The summary judgment decision failed to acknowledge the special acts transfer of the Commonwealth Tidelands public trust rights to the BRA for the public purpose of urban renewal. It failed to acknowledge the BRA and DPW's implementation of the special acts and adherence with Chapter 91's regs. And it failed to acknowledge the rehabilitation agreement and its authorization as essentially the equivalent of a Chapter 91 license. DEP resolved all of these factual issues against Commercial Wharf without submitting any evidence of its own into the record. No affidavits, no documents, no testimony, no evidence whatsoever in what supposedly was a de novo agency proceeding. DEP's opposition to Commercial Wharf's motion for summary judgment was 2 pages without any evidence. What happened here is that the DEP had their result from the outset and they worked backward from there. DEP in this case is trying to reverse 40 years of precedent and the status quo unchanged on Commercial Wharf. There are fundamental property rights of Commercial Wharf's home and business owners that are at stake in this case. Summary judgment, especially in agency proceedings, should be reserved for the clearest of cases where there are no facts in dispute.
If I understand correctly, I mean, this is a difficult case to follow, but you're suggesting the urban renewal plan is where the parking rights generate from.
Correct, Your Honor. So the urban
So they were not issued through any legislative act per se. In other words, there was no legislative act granting parking. And there was no DPW or DEP license to authorize the parking. That the transfer of ownership to the BRA with its proposed urban renewal plan, and because the urban renewal plan suggests that the condominiums would have parking, is where you're saying the rights generate from and have never changed.
Correct, Your Honor. So the urban renewal plan, specifically with respect to Commercial Wharf, it required parking in connection with the specific use approved at the time. The legislature then passes Chapter 663 in order to enable implementation of the urban renewal plan, which of course had specific uses for specific parcels. And in doing so, it granted the BRA all of the Commonwealth's rights in those tidelands in order to permit implementation of the plan at the time. The BRA, then holding the Commonwealth's rights, actually did in fact approve Commercial Wharf's redevelopment through the rehabilitation plan. And that agreement, beyond establishing the uses, also allowed and permitted parking. It included plans that show the exact same configuration, which includes parking and the vehicular access at issue in this case. And the land itself did not change then, and it hasn't changed since. There were no structural alterations to the wharf, which DEP admits in their brief. The wharf itself, meaning the wharf where the parking sits on, that was already licensed. The use
Okay.
flows from the special acts.
Unless there are other questions, we're gonna have to leave it there. Seeing none, okay, thank you.
Thank
Mr. Schofield.
Thank you, Justice Meade, and may it please the court. Seth Schofield on behalf of the Massachusetts Department of Environmental Protection. What is at issue in this case is whether the association needs a license under the Waterways Act for a small portion of Commercial Wharf, which is currently used as private parking and for vehicular access. Below, the department correctly held that the parking use is not authorized either by a special legislative act or a waterways license. It's undisputed that no current waterways license has ever issued approving that use. This case largely turns on, and in our perspective, is resolved based on the text of the 1964 Act, which unambiguously confirms that the legislature did not, through the Act, the 1964 Act, that is, approve the private parking use at issue in this case. Here's what the Act did. Section 2 of the Act conveyed to the BRA the Commonwealth's title to land within a large area on the Boston waterfront and in Boston Harbor, for which the Commonwealth, and this is important, still held title at the time of the Act. Second, Section 3 of the Act modified the Waterways Act licensing scheme within the covered area by giving the BRA authority to veto any DPW issued waterways license issued before January 1st, 1971, a deadline which was later extended to January 1st, 1977 by the 1972 Act. Section 3 of the Act suspended Chapter 91, Section 15. That section, Section 15, empowered the legislature to revoke any prior authorization for work on tidelands. So that Section 3 suspended that by making every license issued by DPW under the 1964 Act irrevocable. And Section 5 of the Act expressly preserved DPW's licensing authority for activities requiring a license from DPW after the modified procedures expired. Now, here's what the Act clearly did not do. First, the Act did not refer to the downtown waterfront Faneuil Hall Urban Renewal Plan. Second, the Act did not authorize or approve any work or use within the covered area. Third, the Act did not empower the BRA to issue any licenses under the Waterways Act. Fourth, the Act did not convey title to the land at Commercial Wharf to the BRA because the Commonwealth did not hold title to those lands at the time of the 1964 Act. Instead, the Commonwealth had already conveyed those lands to the Commercial Wharf Corporation in the early 1800s under the 1832 Act, Chapter 51, and the 1839 Act at Chapter 25. Thus, the 1964 Act's text dictates the outcome in this case because the department correctly held and the Superior Court affirmed the legislature clearly did not in the 1964 Act authorize any new use of any of the tidelands within the urban renewal area. Before, I'd like to just quickly address my brother's reference to the case of Newbury Redevelopment Authority versus Commonwealth, which was cited for the first time in their reply brief. That case actually supports the department's decision, and I'll tell you why. First, the court clearly stated that, quote, nothing in statute 1962, chapter 702, diverted and the covered tidelands to another public use. And that's at page 240 of the decision. Instead, the court made clear that all, in quote, all that was transferred was title to the tidelands. In other words, the jus privatum, not the jus publicum, that is the right to regulate, the Commonwealth's right to regulate use of tidelands under the Waterways Act, which was expressly reserved in that act as it is in the 1964 Act. Second, the court reinforced that point by adding that Section 3 of the Newburyport Act, which parallels Section 3 of the 1964 Act at issue here, quote, represented an exercise of the Commonwealth's power to regulate what the authority, that's the redevelopment authority, could do with the property. Third, this court would not have said those things if the Newburyport Act had actually authorized the Newburyport Redevelopment Authority to use the tidelands covered by the Act in any manner consistent with its urban renewal plan. Thus, far from supporting the association's claims here, this court's Newburyport opinion confirms the correctness of the department's final decision. Unless there are any questions from your honors, the department would rest on its brief.
Seeing none, I thank you both, and we'll take this under advisement.
We are live.
Welcome to the appeals court. My name is Justice Meade. With me today are Justices Vuono and Lemire. Will be your panel for this case. We hope we won't have any technical difficulties, but if we do, we will reestablish contact with whomever, and no one will be docked any time. You'll have your full 15 minutes. You need not use all of your 15 minutes, and we do not entertain rebuttal. With that, I'll call the next case 2019 P1614, Anna PAZ-YORK versus Brian York. Mr. Barrett.
Thank you. Good afternoon. Matthew Barrett for Brian York, the appellant. May it please the court. We are requesting today that due to the lack of subject matter jurisdiction over the divorce in this matter, that this court vacates the improper judgment issued of the lower court. The error within the record is clear. The probate court did not have subject matter jurisdiction over the divorce of the parties, and therefore the lower court should have granted the husband's motion for relief pursuant to Rule 60, or at a minimum conducted an evidentiary hearing on the issue of subject matter jurisdiction.
Well, you want us to vacate. Can we just send back for a further hearing on the subject matter jurisdiction?
I think at a minimum, it has to go back on that issue, but I would go further than that. And the reason is the operative dates that are without dispute within the record. And I believe that's why it should be fully vacated. Here's why. The parties there's 3 dates that are operative. The parties last lived together in Bogota, Colombia on March 30th, 2017. This date is without dispute by either party. Second, the breakdown date of the marriage is April 1st, 2017, not according to the husband, but according to the wife, which is 2 days later. And
that's in the complaint.
Correct, John.
And there was nothing in the hearing record that clarified that further, correct?
Correct. That's
now,
correct.
I noticed in the docket, there's an affidavit of irretrievable breakdown. It's paper number 4. And I cannot find that in the record here. It's just listed on the docket. So I'm not sure if that would have any further information regarding where she was domiciled at the time of the irretrievable breakdown.
Well, I would point you to record appendix page 9, which I think is the most operative data point regarding the breakdown date of the marriage. And that is the testimony under the pains and penalties of perjury of the wife, where she was specifically asked by the lower court about April of last year, 2017. That's when you began to believe that your marriage with Brian was over. You're not going to be able to stay together. And the answer was correct. So,
right, but it doesn't address where she was living.
No, it doesn't. But
and I don't know if that affidavit does.
I I don't have that.
The judge would have had that affidavit.
I don't have that information for you. I don't believe it's contained within the record appendix that we submitted. But what I can say, to your point, is that no, it was never inquired by the lower court, one, and two, it's the husband's affidavit that states unequivocally that the wife was in California. And so that would be what I would argue to this court. On the record that the lower court had, at the very least, there's a dispute, to your point, but I think it's fairly clear that in May, according to the husband, the wife is living with his parents. That doesn't happen with his mother. That does not happen until May of 2017. So at that point, the wife cannot assert now that the marriage broke down within the Commonwealth because she wasn't present in the Commonwealth, and therefore the judgment should be vacated. That's what should happen. And at a minimum, it needs to be returned to the lower court, because under either exception or 2.8 Section 5, the wife cannot avail herself of subject matter jurisdiction within the Commonwealth. She wasn't.
So without getting into where they are now or where they're situated, but you understand if we vacate, they're still married.
Correct. And I think what would happen is, if it goes back, is this matter will quickly resolve itself. And I think that if we had had the opportunity to have been heard by the lower court, it would have become clear to the lower court that there wasn't subject matter jurisdiction. We could have corrected it, because now Mr. York had counsel, and we could have corrected the record, probably reached, I would hope, a separation agreement, and we wouldn't be hearing you for today.
All right.
Did he
So
not have counsel at the, I'm sorry, Jim, did he not have counsel at the time when he missed the hearing?
Correct. He did not.
Well, as I understand,
we filed, there was some delay in the docketing of this, and I thought we were very lucky in that the matter wasn't docketed for some time because the judge changed jurisdictions. And so I felt that by filing the motion and getting it before the judge, we'd be in that position to say, hey, there's an issue with subject matter jurisdiction. We can go out the hallway. That time there were hallways, and we could fix this, and it would have been corrected, and you would have ended up with such a one-sided, verbatim adopted judgment. We would have had a fair and equitable judgment. We would be able to handle the issues of custody and the division of assets, and it could have been rectified. But the fact of the matter is, it was not. The fact of the matter is, I don't think the wife can now say, when she's testified in court in front of the lower court in April, that the marriage breakdown was April 1st. The other problem is, how could she possibly have domicile on April 1st? I mean, it's such a brief period of time, even assuming her argument at best, can you establish a driver's license? Even if she was living, to the point potentially maybe she disagrees, she was living in Massachusetts. I just don't see how 2 days or a day could really allow you to have that intention. And that's why, the statute is so important, because it renders it meaningless if we don't adhere to those dates, because anybody could come to the Commonwealth and file. But this case could easily be corrected if it's sent back. But I would go further than that, because I just don't think that anybody a reasonable judge could conclude that there would be enough time between when they left, when they both agree on this record, that April 1st being the operative date would be enough to establish domicile. And that's why I do think it should be expunged and just go back.
And she would have to establish she had been in the Commonwealth for a year when she filed the action, is another way of establishing.
Correct. That could fix it.
And that clearly did not occur.
It clearly did not occur on this record. And I just think the operative dates are so, the reason why I point you, the panel, to the operative dates is they're just so compelling that I think this is a clear error that requires the reversal of the divorce judgment. These parties will get divorced, but I think, and that'll enable them to get divorced in a fair and reasonable manner, in an equitable manner, as required by the statute. If you don't have any further questions, I will rest on our papers at this time.
Just, I'm assuming if we vacate the judgment, we need not address your other argument regarding the distribution of assets.
Yes, right. I'll stand on my papers for that aspect, but I don't think you have to reach that. Well, but no questions. I will stop. Thank you for your time today.
Thank you. Mr. Higgins.
You're on mute
yourself.
Hitting it hard right out of the gate. Sorry about that. Good afternoon, and may it please the court. A review of the transcript and the inquiry conducted by the trial court in this matter suggests that the court had made a decision concerning both domicile and the timing of the irretrievable breakdown of the marriage. It is not asserted that she had a year, so we clearly have to be inside that part of the statute that talks about being domiciled in the Commonwealth at the time the cause occurs. And of course, the case law includes as part of cause, no cause, irretrievable breakdown. That's how the court starts its inquiry. You know, a transcript was produced and filed before anything else happened. Part of that was our efforts to get the judgment to define the issue from the court, because as counsel noted, it was quite some time before that occurred. On the record before you, the court asked about when she had moved to the Commonwealth, and the judge's decision concerning domicile will only be overturned if clearly erroneous. Subject matter jurisdiction is de novo review by you. However, the lower court's decision concerning domicile would be a clearly erroneous standard. And I would suggest.
Can you show us where in the record there is a reference to where she was domiciled on April 1st of 2017?
So, Judge, yes, Your Honor. Judge, there isn't, what it says is she's asked how long she's lived in Massachusetts, and she says for over a year.
That's at the date of the hearing, right? From the day of the hearing.
Yes, so on June 14, 2018, she's asked how long she's lived in Massachusetts, and she states that, on the record, she states that she's lived there for over a year.
So we can assume she's been there since June 13th of 17.
At a minimum, I would suggest, because he issued a divorce, that the court concluded that she had been there in April of 2017, because it's part and parcel of the same inquiry, Judge. And we're on page.
So I think what you're saying is that there's an implicit finding that your client was domiciled in the Commonwealth on April 1st, 2017, but there's no explicit finding. Is that correct?
Agreed, Madam Justice. Agreed. When the court is conducting this inquiry, it's on pages 8, 9, and 10 of the record, is that portion of the transcript in which the court is asking those questions. And I think it's important to see that the court is asking those questions because the court understood that he needed to make a decision concerning this. So the questions are asked about when the breakdown occurred, how long have you been in Massachusetts, and based on those answers,
doesn't the absence of an explicit finding cut against that argument?
Well, it certainly doesn't strengthen it, Madam Justice. Well,
I appreciate your candor there.
I mean, of course, I would be thrilled to be able to, in retrospect, proposed findings of fact having been submitted by us would have been fantastic. And that's what I would wish for and hope for. However, on the record before us, I do want to emphasize it's important the court did conduct an inquiry on the subject of subject matter jurisdiction and went forward and issued a judgment. And I think that as the court suggested the term implicit finding, that subject matter jurisdiction.
Was there an evidentiary hearing on subject matter jurisdiction?
The only hearing would have been what was conducted and what you have your own.
Did you represent the wife in the probate court?
Our firm did. Yes, my partner did, Your Honor. Mr. Justice.
Husband says that there was a representation to the court that he didn't want to be at the pretrial hearing. Did your firm make that representation?
I believe the client did. In the transcript, it's the client, Mr. Justice.
What was that based on?
So we're running a field of the record, but what I would say is she was living with his...
She testified to it. I think you can stick to what she said in the transcript about that. Correct?
I can, but to answer the question, I can, Madam Justice. They were staying at the same place. She was living with his mother, and that's in the affidavit. That's throughout the record. He came up from Columbia. They were in the same house that morning when she drove to court. She also made those representations the week before because this matter was continued because he was in Massachusetts and chose not to participate, and then chose not to participate for 1 year after this hearing occurred. So the basis of the representation was the conversation she had with him that morning as she was before she drove over to the courthouse.
And so then the judge, did he have some concern because he sent a court officer in the hallway to yell out the husband's name? Is that standard practice in the probate court?
That I have seen happen in numerous courts, Justice Meade. It's very common before, for example, if we're going to default somebody in a criminal case, I've often seen trial court judges ask the court reporter, please go out in the hallway and yell for him. Come back in, they'll notate the time, such and such time, the court officer did this, they're defaulted. In this particular case, you'll note from the record that the court had on the pretrial, based on our request for a continuance, our client's request for a continuance, because he hadn't shown, continued it for 1 week, wrote out the implications of what would happen if he did not show. And I believe that was similar to we've seen in several courts, a formality that the court was doing to make sure that he in fact was not there.
Mr. Higgins, just going back, a point Mr. Brock made, you're suggesting it could be an implicit finding, but it's domiciled, not just being present in the Commonwealth, it's domiciled in the Commonwealth. And she said, it was clear that they last lived together 2 days before the breakdown occurred. Is that, can you implicitly indicate that she would have left on the 30th from Columbia, arrived in Massachusetts, and determined it was a domicile at that point? Is that all part of the implicit findings that you're asking us to uphold?
Well, yes, I am, Judge, based on the record that's before you. Of course, as I know that the panel's well aware, domicile is actual residence with the intention to remain permanently. So when I arrive at that.
But doesn't your partner indicate during that hearing that although she's present, she would probably be leaving at some point because her family's in California?
Yes, Judge, at some point, but what domicile requires per the Rose case is actual residence with the intention to remain permanently for an indefinite time and without contained purpose to return to a former place. So yes, she may go there someday. That falls right in line with that language of an indefinite period of time.
All right.
And that's Rose, which is cited in the briefs, and it's at page 560. So the court takes pains to go through and do an examination concerning the subject matter jurisdiction in this case, and the court implicitly finds that it does exist. The court then takes the proposed judgment from my partner, conducts a further hearing, and order to determine whether the proposed judgment was proper. And with regard to Section 34, Mr. York was not present, and therefore, having been given a chance, an opportunity, a notice of what would occur if he did not show up. Therefore, any evidence that he would have presented under Section 34, any arguments would be deemed waived, and waiver is allowable under the holding of the Putnam case. In Putnam, as the court may know, there were two appellate decisions in that. It came up once on failure to present evidence and have it considered under Section 34, was remanded to do so, and the party stood up at trial and said, we rest. And it held that a court need not consider those factors which the parties do not put evidence on, that they would in fact be waived. Likewise, waiver would apply to the wife in that situation to the extent she did not make arguments. Through counsel and through the inquiries of the client by the court, there were points made concerning Section 34 to support the proposed judgment as adopted by the court in this matter. And I would, if there's no further questions, I would rest on the brief.
May I ask you one question, and you may decline to answer this, but are you as optimistic as your brother that this is a case that's going to be easily resolved, should in fact it be remanded?
No.
Okay.
There are.
You don't have to say anymore.
But on that point, to follow up, if this court does find that the Section 34 inquiry and findings by the court are not sufficient, but does find subject matter jurisdiction, I would ask the court to remand for the property division, but keep the divorce, the resumption of last name, the custody of the child, and the child support in place.
Well, if we go on subject matter jurisdiction, I think the only way that could happen would be by some stipulation of the parties.
Oh, Judge, I'm sorry, I must have misspoke. What I was saying is, if you do find that there was subject matter jurisdiction, however, you find that the Section 34 was not sufficient, I think it could be remanded solely for a property division. If the court finds there's no subject matter jurisdiction, this is heading. There's no judgment. Maybe from the record in front of us, the most appropriate is, it's remanded and the process is started and hearings are conducted on a number of things.
All right, thank you.
Thank you. Thank you both. We'll take this under advisement.
Thank you.